We're here in cause number 19-32623, and we have had some discussions in the back that I think we need to put on the record with regard to the case and where we are. We have, first of all, sir, you're Dalius Williams, and Mr. Williams is here with Mr. Rojos. Mr. Smith is here on behalf of the state. There is a second amended motion to revoke unadjudicated probation. So because the new allegation, I'm not going to accept the plea agreement of the cap of 4 years because there's a new. So I will allow, if Mr. Williams wants to withdraw his pleas of true to 1, 2, and 3. I can go through those again and get pleas today on those, and then we can go forward with what we have today. And then if I feel like there needs to, it's my understanding, Mr. Smith, for today, you have witnesses with regard to proving up count 4 only. Is that correct? So what we can do today, depending on what those pleas are, either way, we'll go forward with what we have because there's witnesses here. And then if I feel like I need to postpone the hearing to another date for the state to prove up more, then we can do that then. So, Mr. Williams, the best you can, I need you to raise your right hand, sir. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, to help you God. Thank you. You can put your hand down. And so, Mr. Rojos, what is y'all's position?
Judge, I think after discussions with Mr. Williams, he would like to withdraw his count.
Okay. So just to go back, count 1, Mr. Williams alleges that you violated your probation by failing to report to the probation department October 25th and December 15th of 2022. You had previously pled true that was true. And do you want to continue to plead true to that count? Okay. And then count 2 alleges that you're behind in your court fees as of January 4th, 2023, in the amount of $3,638. You previously pled true to that count. And do you want to continue with your plea of true to count? Count 3, which was in added in the first amended motion, alleges that you committed the offense of evading arrest or detention July 14th, 2024. You had previously pled true to that count. And do you want to change your plea of true in that count? You want to change your plea to not true? Okay, so we'll enter a plea of not true to that count. And Mr. Smith, I know you weren't prepared, I guess, for that, but have y'all had any contact with the officer? I would think that would be a one witness.
It's actually several witnesses. One house. Two officers.
Okay. 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 All right. So we'll see where we get today then. Mr. Williams is on probation for possession of a controlled substance, and that, which was a 3rd-degree felony. Correct? No. That's been. Oh, it was as well. I've got the indictment pulled up from the injury to a child. That's a 3rd-degree felony. But that possession of a controlled substance is a 3rd degree as well. So the range of punishment is between 2 years and 10 years. And Mr. Williams, I also want to make sure you understand that if we go forward with this motion, and I do end up revoking your probation, then later, if the state does prove, so we have the injury to a child, that new case, if you're found guilty in that new case, then the punishment could be stacked. Do you understand? Do you understand that? Okay. Mr. Rojos, you've gone over all of that with him, correct? And it's also my understanding that y'all had, even in the back, Mr. Williams' mom in the back to go.
Here's where the courtroom turns strategic. Mr. Williams rejects a 4-year plea deal, gambling on the outcome. But this move is risky. If the state proves the new injury to a child case, sentences could stack, meaning more prison time than he'd hoped. High-risk poker in real life. Spade suit collision.
Through everything, what his options were, and all of that this morning. Is that correct? Okay. What if any offers? I want to make sure Mr. Williams on the record rejects anything.
We had offered 4 years case, Judge. Rejected that offer.
Did that include an offer and the injury to a child?
Actually, I offered 4 years to rotate to run in time.
Okay.
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 So then, the trial on me, I would need to stack the case on whatever it was off. They won't get.
Okay.
Oh, I didn't hear what last part of this year. I still thought that 4-year-old today. Because I'm still saying, or if you were trying to do that.
He would request it, and it's up to me. So anytime someone did state ask for a case to be stacked, it's up to the court to do that. So it's not up to a jury. If you go to a jury trial on that injury to a child, what would happen? Let's say you go forward today. We have this hearing. If I revoke your probation and give you any time in prison, then the next step would be to set that injury to a child for a trial. And then if you're found guilty in that case by a jury, then what the state is saying is that they would ask me then to stack that, whatever sentence you might get, if you get a sentence, on top of what happens today in the motion to revoke probation. Do you understand? Okay. And so your options are today, if you wanted to go forward with plea in both of your cases. Plea of true in that motion to revoke for a 4-year sentence. Plea of guilty in the new injury to a child case for a 4-year sentence, with the agreement that those sentences would run at the same time. You don't have to do that. We've got witnesses here. We'll go forward with the hearing. Just want to make sure you understand what your options are today that you won't have after today, and what your consequences could be if you go to trial and if you go forward. And nobody's trying to talk you into anything. I just want to make sure you understand it all. Does that make sense? Okay, so you understand everything that's been offered and what what you could do today and kind of where we're about to go, right? And so what do you want to do? Okay, then we'll go forward with this hearing. So I want to make sure also for the record what all I've reviewed. The original PSI, obviously from being placed on probation, is included with the updated pre-sentence report. Everyone should have that as well. And so when I went back through that, just want to make sure that there aren't any corrections or issues with regard to that criminal history specifically that I'm looking at. Starts on page 1 and then carries on to page 2 on that pre-sentence, or actually it was a post-sentence investigation, I think. Y'all have that? Everybody's on the same page as me. So it looks like there was adult misdemeanor history of 2 thefts back in 2013. Both of those were 30 days in jail. There was a theft of services in 2014 where Mr. Williams received a probation. That probation was revoked in 2016. That's in Rusk County. Possession of marijuana in 2014, Nacogdoches, 3 months in jail. A resisting arrest or search, March of 2015, where there was a probation given that was revoked in 2018. There was then a 2015 failure to appear bail jumping case in Nacogdoches, 2016 burglary of a vehicle, 30 days jail, and then 2019 a resisting arrest again and an evading arrest, also in 2019, both with 180 days in jail. Then the felony criminal history I show is a criminally negligent homicide from 2017, where a probation was given in 2018. That probation was revoked in 2020.
Now we're looking at the full criminal history. multiple revocations, resisting arrest, evading, even criminally negligent homicide. This isn't just a pattern. It's a chronicle of repeated failures to comply. Judges take notes like these very seriously. It's a major factor in sentencing. Books police Garlight.
Looks like that probation was revoked based on, and looking back on all of this, I'm not real sure other than what we were all thinking, but it looks like on January 10th of 2020, the probation was revoked on the criminally negligent homicide. There was a new offense of injury to a child that he appears to have pled guilty on and received a 12-month state jail sentence. There was another offense, new offense, from January of 2019, an attempt to take an officer's weapon. Also same disposition date of January 10th, 2020 for the 12 months in the state jail. And then there was a possession case for here from that same date. So it looks like he took some time on a couple of things and then got probation on the possession. Does that, everybody on the same page as that? I did look back. I think because I have this information, I don't think it's necessarily improper for me to look at some of the information based on those cases. I do have a question specifically with regard to the injury to a child from 2020 that he pled guilty on. What is the relationship with, I was the victim in that offense? So Ms. Broussard has other children that are not from Mr. Williams. So when we went back through, Mr. Williams entered pleas of true to counts 1 and 2. So I am going to find, based on those pleas, counts 1 and 2 true. Count 3 entered a plea of not true, as well as on count 4. I am going to find, based on the evidence presented today with regard to count 4, that there is sufficient evidence to find count 4 true, and at this time I am going to find count 4 true. I understand everyone's position. I think with regard to there'd be different evidence, I would think, and probably more potentially at a trial. I'm not required to look at all that, and obviously the level of the burden is different. So count 4 is true. Mr. Rojos, you may proceed with our.
Judge, I would give you initial claims we have here, I think this time for. And they were recommended information that the device, the possible change after the shot. So he does have received innocent child, and we are not the bond after he won confirmation. For the car, confirmation of life, it's not because we just, we have, of course, consider something in the range, possession, 2 to 4 years.
Thank you, Ms. Rojos.
Yes.
Mr.
Criminal history shows what the usually is unable to probation. Probation also helps their desire to keep him on probation and not charged. Especially a lot of the stuff is one of the things to his job in the last week. That gives me and so more than but doesn't respect authority is shown by jail incident reports. I feel like vote make more active in the last 5 years, 5 or 10 years.
Thank you. And also, just for the record, everybody has those jail incident reports. Those were provided. I've reviewed those as well. Mr. Barksdale's here. Mr. Barksdale, do you, probation officer, do you have anything to add at this point with regard to your position? Okay. Thank you, sir. Mr. Rojos, I would give you an opportunity if you want to. We can ask Mr. Barksdale to come if you have any questions of him.
No.
Okay. And Mr. Williams is 30 years old. You just turned 31. So I appreciate that you have support here and people here to support you, but your behavior to me tells me that you shouldn't be around any children, much less your own. Whatever is happening with you when you're getting angry at these children with what you're doing, because it's the same. This appears to be the exact same type of incident that you pled guilty for a few years ago when I put you on the probation for the possession.
And here comes the emotional hammer. The judge isn't mincing words. Mr. Williams' behavior with children mirrors prior offenses, and the court is drawing a line. Probation isn't working, and protection of the children is non-negotiable. This is where law meets real-world stakes. Stop sign, baby.
And this, it's ridiculous. You and Ashley both don't need to be around any children. Don't need to be having more children. You can't take care of your own children, and you're disciplining them by doing. And I don't think there's any reason for anybody to believe that these. No one said these are scratches. No one. That's not what the doctor said. They're adjacent to these other marks on the back of this 2-year-old. Going to find, again, that you entered your plea of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find count 4 true. Find sufficient evidence at this time to find you guilty of possession of a controlled substance. Going to sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I'm making a notation on this because originally it was a plea agreement, but it was when it was signed. I'm making a modification. Let me change it. This was not a plea agreement, so you do have some rights to appeal. I'm also going to hand you a written admonishment starting regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify.
The gavel drops. 8 years. The judge also reminds him of firearm restrictions and appeal rights. Notice how these legal details aren't just formalities. They shape his life after release. Every probation violation, plea, and guilty finding feeds into this outcome. Balance scale, hourglass not done.
As a firearm, if you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Rojos. Thank you all. I'm sorry. I know this is difficult for everyone, but I have no doubt in my mind that Mr. Williams, not just on this occasion, but probably on many, has obviously improperly disciplined, if that's what you want to call it, all of these children. Court is adjourned.
All right.